I have no audio.
Oh, I'm sorry.
No, okay. Yeah.
I had no audio. Okay. Hey, everyone. It's Paul at the Garland County Library, and I'm here with attorney Eric Wilson, who is with the Shaw Firm in Conway, Arkansas. And several months ago, we posted a survey asking our library patrons what law-related topics they would like to see programs about. And one of the most popular results was laws concerning medical marijuana here in Arkansas. So that's what Mr. Wilson is here to discuss today. And if you have any suggestions for topics on future law-related programs, you're welcome to comment those. And if it's a feasible idea, I'll do my best to find an appropriate attorney or law expert to give a presentation on it. One of the most popular other results from that original survey was laws concerning landlords and tenant rights. So you don't have to suggest that particular topic because I'm already pursuing that one. Like I said, today's installment in our law topic series is about medical marijuana laws. And I did receive quite a few questions emailed to me in advance from some of you. So I've already submitted those to Mr. Wilson here so he could get those addressed in his presentation today. And if you have any other questions while you're watching live, please comment them and I'll read those off to him here at the end. So with all that said, I'm going to turn it over to Eric Wilson here. Welcome.
Thank you, Paul. I really want to thank Garland County Library and Paul for reaching out to me to talk about this topic. I've dealt with this issue in a variety of ways since the law's inception from a variety of people that have come to our firm. What I'm going to provide in this talk is an overview of the law as it is currently. I will not, as a disclaimer, provide specific advice as to particular issues, but I will address the law as it is and provide a useful map maybe for people to navigate it. But at the end of the day, I think it's imperative, and I urge you to reach out to an attorney if you find yourself in any situation that I may present. The structure of my presentation will begin with an overview of medical marijuana as it currently is within Arkansas, how to obtain a medical marijuana card, and how to purchase it. Following that, I will go into the more substantial topics that I'd like to cover. These include questions regarding employment and medical marijuana, questions at the intersection of criminal law and medical marijuana, and the topic that I received the most questions and comments about, which undoubtedly was how guns and medical marijuana intersect, which I think is important, and I will stress its importance once we get to that point of the presentation. With that said, Paul, if you can transition to my presentation. I felt it easier, by the way, to just put it in a way for people to easily digest. I think information is more easily understood if you have fixed points which to refer to, and hence the reason for the slides. But let's go ahead and get started. The Arkansas Medical Marijuana Amendment of 2016. This is the actual amendment to the Arkansas Constitution that permitted medical marijuana to be sold at all. It specifically provides protections for the possession and use of marijuana for card recipients. It allows for a recipient of a card to have up to 2.5 ounces of usable marijuana every 14 days. And it has several articles within that amendment. I can't remember exactly, maybe 28, 30 articles. I'm mostly going to be concerned with Articles 1, 2, and 3 of that amendment because they provide the protections for the use of medical marijuana and define important terminology, I think, that people need to know in order to make use of those protections. So just a note, it does create what's known as the Medical Marijuana Commission. Their job is mostly relegated to the regulation of the industry, both in the dispensaries and the cultivators that grow it, and the licensing of testing, and it directs the Department of Health to administer and enforce the amendment. The Department of Health then determines who qualifies, what qualifying conditions allow for the use of marijuana, and ultimately they're in charge of issuing cards to people. So these are the qualifying conditions as they currently are in Arkansas. I'm not going to read all of them. It would be too much, but of importance, I think it's important to note cancer, glaucoma, PTSD, severe arthritis, Alzheimer's, hepatitis C. I think those are the more well-known ones, but it's important to note that it does also permit for qualifying conditions that may be symptomatic of a different condition. These can be intractable pain, severe nausea, and severe and persistent muscle spasms associated with multiple scoliosis. What about anxiety, depression, ADHD, etc.? And a lot of these slides are phrased in common questions for people to easily understand the situation and the law as it relates to it. One of the most common questions I'm presented as an attorney is, well, I have anxiety, depression. Do you think I can get medical marijuana for it? The short answer is no. Diagnosed anxiety and depression are not enumerated as a qualifying condition. But there is a process that a person can take to petition to include these. If you review the ADH website, the only thing that has any mention of a petition to add a new condition was bipolar affective disorder. And these are links to the actual petition that qualifying patients submitted, and then the actual decision reached by ADH. They denied it. And unfortunately, when you review the decision, there is no reasoning provided as to why they chose to reject it, which I find unfortunate for the point of discussion. So you have a condition. What do you do now? A doctor must sign and confirm a certification form that states, in their professional opinion, after reviewing the patient's medical history and current medical condition in the course of a physician-patient relationship, the patient has a qualifying medical condition. Please note that once you get this done with the doctor, it's not a prescription. It's just the first step, really, to getting your medical marijuana card. Here is a picture of the physician written certification as provided by ADH. It states specifically what I just told you on the last slide, what the doctor has to verify for purposes of submitting this form or this certification to ADH. And they will indicate that you do have a qualifying condition, indicate what that condition actually is, provide you how long you can use that, and provide information to ADH of who they are and that they are a certified doctor or a licensed doctor. And next to that is the actual application that the patient with a qualifying condition must complete and submit to ADH in order to begin that process of actually applying for the card. Does it cost anything? This is another common question that I've been presented with in a variety of ways. The doctor visit can average anywhere from $100 to $200. ADH doesn't provide you with a source or a list of doctors. It's your responsibility to actually reach out to a medical provider and have them sign the certification for you. This has provided some difficulties for some people with qualifying conditions. However, in response to that, I'm sure if you have driven on any interstate in Arkansas, you can see specific facilities or clinics devoted to providing the service to people. So it has, in response to a lot of things, generated a new type of business, I would say. Application fee to the Arkansas Department of Health. You have to pay $50 in order to satisfy what the ADA wants. It's an application fee. Pay your $50. So you submit your application form, your physician written certification form, a copy of your driver's license, and the $50 application fee. It takes about 14 days, ADH reports on their website, to actually process your renewal. And that card is valid for 1 year unless for some reason the certifying physician limits the time in which they think you actually require use of medical marijuana. The picture provided is a sample of what a card actually looks like. They look very similar to that. They'll provide your photo ID with other identification, very similar to a driver's license in form and function in some ways. Common questions that people ask once they actually get that card in their hand: where can I buy it? Right now, there are 38 dispensaries approved across the state. 32 of them are open. Those 32 are split up into 4 different dispensaries in 8 different regions across the state. I couldn't tell you where the additional 6 are opening. I want to say one might be in Morrilton, Arkansas, or maybe it has opened, but there are at least 6 more coming. The medical marijuana amendment created a limitation on the amount of growers. There's only 8 cultivators permitted, and all 8 of those licenses have been granted. They had to submit an application to be approved to grow, and basically the 8 best applicants were chosen by the Arkansas Marijuana Commission, and I don't know if there's any indication that there'll be more growers in the future or not. Another question that always comes up: can you grow it? No, absolutely not. That is a crime. Please don't do that. These are important numbers after we covered how do you actually get your card and where you can buy it and things like that. I think these numbers are very indicative of the importance of medical marijuana as it exists. The first purchase was in Garland County on May 10th in 2019. It took approximately 3 years for the program to actually get up and running after substantial litigation leading up to the point. As of April 10th, there's 74,779 people with active cards. That's not an insignificant number here in Arkansas. I think you're approaching maybe 2, 3, 4% of the population off that. I would need to do the math, but that's a significant portion of people who have made use of this program in the short time that it's been available. I think that merits consideration for people looking into this and the worth of it for a significant population of the people. 42,000 plus pounds of marijuana have been sold as of 5 days ago. They post numbers regularly or provide those numbers to the public. And $285 million in sales. I read somewhere that on average right now, Arkansas medical marijuana patients are spending approximately $880,000 a day on medical marijuana alone. It's generated tremendous monetary value since its inception, I would believe, based on those numbers. 38 dispensaries, 8 cultivators, as I've mentioned. So it's important to realize these are not insignificant numbers. This is a general map of the medical marijuana dispensary zones as created by the amendment and the commission. Each zone is allocated 4 separate dispensaries. Like I've said, since this map was generated or created, there have been 6 additional dispensaries that have been approved, I think would be the right term to use here. And they're still in the process of opening. As to where, I can't say. This map doesn't indicate that, and I'm sorry for not looking that up. But I think it's important for people who choose to take advantage of this program or use this program to know these locations. So this is the general overlay. There are 2 in Hot Springs, I believe, or 2 in Garland County, I should say. 2 in Pulaski County, at least 3 in Pulaski County, 1 in Faulkner. It's all over. This portion is, I think, the more important part of the talk, as I was kind of hinting at toward the beginning here. I'm going to cover what I would note as substantive questions of law that people have. I've tried to limit the legal terminology, and I've tried to limit the detail that I provide in order to give an easy answer for people to digest, because these are real questions that I've been presented. And the answers to these questions have real effects on people. And I think that's always important to take into consideration when you're talking about this topic. I want to preface this by saying that my specialty is undoubtedly in criminal law and in administrative law. But I do know enough about employment law, I think, to navigate it for everybody, because this is very relevant. And If you are ever in any of these situations or have to confront these situations, I would implore you to reach out to an attorney to help you in these situations. So take that how you will. And probably the number one question that comes to me, can I be fired from my job for using medical marijuana? In short, the answer is yes, absolutely. The employer has a lot of discretion as to how they implement the policies of their workplace. If you are ever confronted with this question, the first thing you can do is always look at your employer's policies. Some employers are being really proactive in addressing this. They will verbatim say, you cannot use marijuana, here's the reason, or yes, you are welcome to use it if you are in lawful use of a medical marijuana card, and as long as you don't come to work impaired or under the influence. And even the constitutional amendment that was used to create medical marijuana in Arkansas contemplates that scenario, providing that you do not have to permit anyone to come while under the influence. Basically, it's analogous to the use of any other prescribed drug, I would say, to some degree. That includes people that may use opiates or Xanax, benzodiazepines, things of that sort. That's how you can look at it, I think, with your employer. It's important that you look at your employer's policies, though. There's not a blanket policy, though, to answer the question of can I be fired. So it does come down to who you are employed for. I think that's very important. If your job has an HR department, talk to them. If you have legitimate concerns. The constitutional amendment does have exceptions to when medical marijuana can be used and employed, and I will talk about that later. But this is just the general answer. Similar question, can my employer prevent me from using medical marijuana? Yes. You can't work while under the influence of it. And the constitutional amendment defines what under the influence means. The legal, I guess, backbone of what the definition is. It's symptoms of the current use of marijuana that may negatively impact the performance of the job duties or tasks or constitute a threat to health or safety. And the definition in the amendment goes on to define symptoms of intoxication. I do think they run into issues, though, when they try to enumerate too many things, but that's for a different talk. Does my employer have to accommodate my use of medical marijuana? No, not at all. You can't take a marijuana break, as someone has phrased it to me. A client has. You cannot do those things. That should be obvious, I would think, to some degree. Again, analogize it to the use of any other intoxicant that may impair your ability to do your job. Just don't do that. Remember that definition from the previous slide. No employer or any person, like you can't go to someone's house and just suddenly use marijuana there just because you have a card. They don't have to accommodate that use. If that person is in lawful use of their property and you were there as an employee or a guest or a visitor, however you want to phrase that. It's a liberty that you get to use marijuana, but it's a liberty that is defined by very definite boundaries. I think this is important to realize. The Arkansas Constitution addresses this to some degree. It provides protections for the medical use of marijuana. Specifically, it says that an employer shall not discriminate against an applicant or employee in hiring, termination, or any term or condition of employment, or penalize that applicant or employee based upon the applicant's or employee's past or present status as a qualifying patient or designated caregiver. So what that means, to make it more simple and easy to understand, is that an employer cannot hold it against you or make an adverse decision with you or against you just based on the fact that you are a qualifying patient or a designated caregiver in the medical marijuana program. That is I'm not familiar with any litigation that has been generated from this, and if anyone ever comes across it, I would very much like to know how this particular part of the constitutional amendment has been used or interpreted. But you need to look at it in contrast with the Americans with Disabilities Act. I think that's the easiest way to probably understand it, honestly. To bring a claim, this is how lawyers talk, by the way, and I apologize for that. To bring a claim under the ADA, a plaintiff must prove that they actually have a disability, that they were discriminated against by being excluded from or denied benefits of a public entity's services, and that they were discriminated against because of that disability. I would think that in some capacity or in some way, a claim under the amendment would be analogous to this. Again, I don't have any substantial litigation within Arkansas to base that off of, but that seems to be the area where they're talking about. You need to also remember that the amendment provides the employer with a lot of authority. This is really important. The employer has the right to establish and implement a drug-free workplace policy, and that includes drug testing that makes you comply with federal law. So they can implement a policy to prevent you from using medical marijuana. They can also terminate you for the use of medical marijuana or if you're under the influence of it. And an interesting thing down here is that it excludes a patient from employment in a safety-sensitive position. That's an important word there, safety-sensitive position, because that actually means something very real, and I'm going to talk about that. An employer is protected to take measures to assess and supervise the job performance of an employee. They can reassign that employee. They can place an employee on paid or unpaid leave for a variety of reasons, I would imagine, just so long as it's not based solely on the fact that they are a medical marijuana participant. They can suspend or terminate an employee, require an employee to successfully complete substance abuse program before actually returning to work, or they can just refuse to hire the applicant. And the employer actually has absolute protections as to this, meaning that a cause of action, when I say cause of action, a lawsuit, that means a person can't sue somebody or can't sue their employer under a discrimination claim under the constitutional amendment based on one of these actions, as long as the employer provides a reason distinct from the person actually using marijuana. So consider that. And again, if anyone encounters this in any way, shape, or form, I would encourage you to reach out to an attorney, myself, or anyone that may have knowledge of this area. I think this is very interesting and merits litigation. What happens if I fail a drug test and I have a medical marijuana card? The employer can terminate you or prevent you from receiving workers' comp. If you refuse or just don't take the test, an employer can take a similar action or find somebody who will actually take the test. Again, the employer has a lot of discretion here. Don't think just because you have a medical marijuana card, you can do what you want in respect to your job. This is what I was talking about earlier, safety-sensitive position, because it precludes a lot of people from actually using medical marijuana. So think about this. If you have a medical marijuana card, know someone who has a medical marijuana card, and they are thinking of applying for a position with anything that may involve this. A safety-sensitive position, by definition, is any position involving a safety-sensitive function that requires federal regulation. The biggest example is commercial trucking. A commercial trucker may not use medical marijuana even if they have a card, because that is dictated by federal guidelines and federal laws. Therefore, they are forbidden to actually use marijuana in any of its forms based on the dimensions of their job. This also includes a position where the use of marijuana could impair the performance of that job. This could include teachers. It might. I think the teaching authority or the school has discretion as to how it's implemented. Another good example would be a state prosecutor. This includes jobs that involve carrying a firearm. Think a police officer. performing life-threatening procedures, emergency room surgeon, working with confidential information or criminal investigations. That includes CID and, well, investigators and prosecutors and people involved in those departments, and people that work with hazardous materials or medicine. And there's a catch-all at the end of the definition that says that any job where a lapse of attention could result in injury, illness, or death. So if your job is dangerous in any way, I would think that it would preclude you from using medical marijuana. If you're uncertain, this is a conversation that you probably need to have with your employer or an attorney to help navigate this area. Does this mean all drug testing? Yes. Before you're hired, while you're hired, random drug testing, anytime that the employer may think that you're using medical marijuana or any other intoxicant for that matter, anything that could impair you. Yes, it includes all drug testing. This is an interesting thing I found while looking at this. What do some of the biggest employers in Central Arkansas say? City of North Little Rock and City of Little Rock are being pretty proactive in this. It's protected within limits, just as long as you're not a resource officer or driving a school bus or something, then you can't use medical marijuana. UAMS, similar position. They won't take any action against an employee that tests positive as long as they are in lawful use of marijuana, medical marijuana, and have a card along with it. Again, the Arkansas Trucking Association, it's prohibited absolutely. Can't use it at all. Don't think about using it because of the federal realm of that. I'm going to transition now to more criminal law. This is my area of specialization, you could say, competence, however you want to phrase that. And I'm going to go through common questions I get as a criminal defense attorney, and then I'll talk about gun laws, which also intersects with what I do currently. I'm a person's on probation. Can they use medical marijuana? It really depends. The conditions of probation in Arkansas provide that a person on probation must follow state and federal laws. Marijuana is still legal, obviously, under the federal law. So at first, no, you cannot use it. There's a process that a person has to adhere to. They have to inform their probation officer that they have a card and request permission for its use. They have to then petition the court for approval to use the marijuana. And then the petition can either be approved or denied. So even after you get the card and you submit the petition and you're on probation, can the judge ultimately deny you? Yes. There are some judges in Northwest Arkansas who do a case-by-case analysis. They look at whether or not marijuana or being intoxicated was a substantive part of your crime, and they make a decision based on that. Often, in my review of some of these petitions around Arkansas, a judge has a tendency sometimes to side with the voters of Arkansas, as they put it. And I think that is interesting, but often it's a case-by-case basis. If you're ever faced with this situation, please contact an attorney to do this for you. If you are having any difficulty with it, this is something that could benefit from having an attorney. What if I test positive for THC while on probation and I have a card? Well, the probation officer can revoke you if they want, or they can take administrative action against you. What that means is that they can initiate a new case against you, saying that you violated the conditions of your probation, or they can go ahead and take an administrative sanction against you. And they have a lot of discretion on what they can do. Most often, it's usually a few days in jail, like shame on you for revoking your probation, or they mandate regular drug testing to make sure that it doesn't happen again. If you are faced with administrative sanction in this situation, an attorney has very limited authority in how to help you in it. So again, if you are in this situation or know someone who has or have a family member is in this situation, please contact an attorney. You're dealing with your civil liberties here. Regardless, I think it's important to follow the procedure in the previous slide. You can still get a card if you have a record of any shape or form. A qualifying patient does not have to have a clean record. However, if there's a caregiver exception here. A caregiver is somebody who is authorized to buy marijuana or pick up marijuana on behalf of a qualifying patient. Those people are subject to background checks. So if you are looking to be in that position, please note that you will be subject to a state and federal background check. Now that medical marijuana exists in Arkansas, Did it change the criminal law at all about marijuana? No, not at all, unfortunately, for a lot of defendants. Less than 4 ounces is still a Class A misdemeanor, Class D felony for more than 4 ounces, 10 pounds or more, C felony, 25 pounds or more, B felony, 100 pounds or more, you're looking at Class A felony. What does all those classes mean? This is what it means. It means that there are some crimes that involve marijuana that in Arkansas can still put a person in prison if you have that amount. This is a general overview of it. Misdemeanors up to 1 year in jail, $2,500 fine. Class D felonies 0 to 6 years, Class C 3 to 10, and so on, based on the quantity that you're caught with. So it didn't actually change any of the criminal statutes that create our laws here. I think this does merit reconsideration to some degree. I've been charged, this is a question I get asked a lot as a criminal defense lawyer. I've been charged with a marijuana-related crime. If I get a card, will it help me? No. A clever attorney might be able to use it to their advantage in some degree for negotiation purposes, but overall, you're charged under the circumstances that were present when you were arrested. If you were arrested at a time when you didn't have that medical marijuana card, just because you get one doesn't make your previous unlawful use suddenly lawful. Okay, this is very important. If you are charged with anything involving marijuana, reach out to an attorney. It's the easiest thing to do. It helps to have a professional navigate this area for you, undoubtedly. Again, if you don't understand this reasoning, think about if you illegally held prescription pills that weren't yours, something like that. It'd be a similar situation. Just because you later get that prescription or later get the approval to use that substance doesn't mean you suddenly can use it, or so that it makes your previous use lawful, I should say. Sorry. This is a common question for people that have cards. I have a card and I got pulled over, but I left my card at home. What do I do? It may be hard to convince the arresting officer that you are a card-carrying patient. It really depends on a lot of factors. You also can have a digital copy of your card on your phone, for just so you know. I think it's important that if you do have a card, to the ADH website and put a digital copy of your card. They do provide a process by which you can do that. It's all on the website. If you're arrested and you actually have a medical marijuana card, the amendment provides for an affirmative defense. And again, I'm not familiar with this actually being used actively by a defense attorney, or at least I haven't come across it during my tenure, I guess you could say. But it provides that a possessor of a medical marijuana card or a qualifying patient with a medical marijuana card doesn't actually have to be an actual physical possession of that card. And it forbids disciplinary actions by businesses or licensing boards if you're prosecuted and have a card. Again, I've never seen an administrative action taken pursuant to that, but if you're in this situation, please contact an attorney. Myself or anyone else would be happy to help, because often a person is charged with a crime for whatever reason it may be. And being charged with that crime impacts your ability to do your job. They might revoke your license, suspend you, etc. And that creates a whole other mess of problems for you. So consider this if you're ever in this situation, to have an attorney look into this for you. Are DWI laws the same for medical marijuana users? Yes, just to make it clear. DWI is actually defined. There's a couple of definitions for what amounts to DWI in Arkansas. But it's unlawful for you to just be intoxicated or in control of a vehicle or a motorboat or anything in the state. And that particular area of the law, that statute, is defined. What intoxicated actually means. It just means that you're influenced or affected by the ingestion of a controlled substance, or any intoxicant for that matter. Just because you have an Ambien prescription doesn't mean you can take that Ambien prescription and then go drive to Taco Bell or something like that. It's important that you realize the limits of what you can and can't do while driving. This was a question presented, so I included it in here. I want you to, I included this also, consider local efforts of communities to be proactive. Eureka Springs, as early as November 2006, made adult marijuana arrests lowest priority. Fayetteville, November 2008, lowest priority. Little Rock has tried twice now. Both measures have failed for whatever reason. However, as we speak, I believe this is being tried a third time. Hopefully, something will be done. So there is measures taken on a very much smaller community level to address the issues of the changing laws of medical marijuana in respect to how the criminal law is actually implemented. This is a new and emerging thing. Okay, I'm going to talk about guns now. It's the biggest thing. It's the easiest. I'm going to go through it as quick as I can because I'm running out of time and I'm talking too much. Is there a provision in the Medical Marijuana Amendment that says I can't own a gun? No. The Medical Marijuana Amendment does not actually talk about guns specifically. I put this in here because some questions that are presented seems to suggest that people think there's something in that amendment that says they can't own a gun. It's not in that amendment. What they're talking about is something different. This does not mean that you can have a gun, but within that amendment, it's not there. So what are people talking about when they say I can't possess medical marijuana and own a gun or buy a gun? They're talking about the Federal Gun Control Act of 1968. It's a federal law codified here, 18 U.S.C. 922. It shall be unlawful for any person who is an unlawful user to any controlled substance to ship or transport or in interstate or foreign commerce or possess in any firearm or ammunition. That's a lot of language. Basically, it just means that on the federal level, marijuana is illegal and you can't possess, buy, purchase a gun because of that. That commerce language kind of denotes federal dimension. But that says unlawful use. My medical marijuana card is lawful under Arkansas law. What does that mean? What gives? This is an argument that was tried in a case named called Wilson v. Lynch. Basically, the plaintiff Rowan Wilson, tried to purchase a firearm in Nevada, I believe. And the federal firearms dealer said that she couldn't have the gun because she was a registered medical marijuana user. Didn't even use it, but just had the card. So the issue presented was, does the use and possession of medical marijuana in accordance with the laws of a given state strip the user of their Second Amendment rights? In short, that ruling said yes. The court even went as far to say that the mere possession of a registry card constitutes reasonable cause to believe that the person is an unlawful user of a controlled substance and therefore prohibited from purchasing a firearm from a federally licensed dealer. I think this is what people are getting at when they're talking about the gun issue with medical marijuana. How did the court reach that conclusion? Well, they just said that it was what the government provided as the reason was reasonably related to an actual interest. They just wanted to lower abuse of drugs and gun violence. That's reasonable. And they said that only the manner which Wilson could obtain firearms was burdened. If she wanted to purchase a firearm, the government said that she could just surrender her medical marijuana and invoke her Second Amendment right. But she do that in litigation and reached the conclusion that we have. This is something else that people are talking about. Yes, the federal government has taken steps to make this decision known. Form 4473, Firearms Transaction Record. If you buy a gun from a firearms dealer, you're going to fill out this form. Question 21E directly addresses this. The use or possession of marijuana, reading what it says, remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside. If you mark yes on that, even if you are a card-carrying user, you're lying, and that can incur a crime on the federal level. Don't lie on that form, please. This is just the federal statute that says that it is a crime. Okay. So what's to concealed carry? The second dimension of the question that people always ask. The right to get your concealed carry is provided in 573-209. There's two specific sections that would suggest that you're prevented from using medical marijuana and possessing a firearm. The first is Section 6, which says that applying to get their concealed carry shall not be subject to any federal, state, or local law that makes it unlawful to receive, possess, or transport any firearm and has had her background checked successfully, whatever. There's a lot there. What that means is if you have a medical marijuana card and you're restricted by the purchase of a firearm based on the Federal Firearms Act provided in the previous amendment, you can be denied being provided or applying or approved for your concealed carry license. And this carries over also into whether or not you chronically or habitually abuse a controlled substance, because it is still classified as a controlled substance. Ergo, if you habitually use medical marijuana, it seems to suggest that to some degree you can be denied approval for your concealed carry license. So in sum, what that really means, to get the idea of the situation, control is an obstacle to a medical marijuana user to purchase a firearm from a guns dealer and lawfully obtain their concealed carry license. Any applicant should be cautious of their decision to get a concealed carry or purchase a firearm, for that matter. What's the solution to this? I think the Arkansas State Legislature needs to address this disconnect between state and federal law for concealed carry. Or a litigant, like I guess right here, will force the hand of the judiciary to clarify this gray area. What does that mean? It means that somebody's going to sue based on this, just like somebody did in Nevada, and see how this actually plays out. And rightfully so, because it is a gray area that does deserve clarification to some degree. I included this in here because this is happening right now, but consider these pending bills before the current legislature. HB 1386, the Arkansas Second Amendment Liberties Safeguards Act, it makes it unlawful for an agency to enforce a federal regulation on a firearm, meaning that federal law wouldn't be enforced in regards to a firearm. The interesting one is the last one, SB 298, the Arkansas Sovereignty Act of 2021. Specifically, it cites the Gun Control Act of 1968. And it says that it has no enforceable authority within the borders of Arkansas. Now, keep in mind that none of these bills have actually passed yet, but I think it does give insight to the situation. How often is it enforced? Not often. There's actually an amendment in the budgeting bill that says that the Department of Justice won't use federal funds to prosecute people who are in compliance with medical marijuana. And as far as I could find out, the Arkansas Department of Health does not actively share card applicant information. So what does that mean in total? It means a lot of things, I think, but I think the safest piece of advice that you can receive about it is from Representative Douglas House. He was interviewed by Talk Business at one point, and he's an attorney as well. And he said, and I can't quote him exactly, but he said, if a client asked me as an attorney, I would say never carry if you have a medical marijuana card. He would say gift those guns to a friend, a family, your spouse, something like that. Like provide a note, making it a gift. And I think that's the safe answer, and in some ways the right answer. These are miscellaneous questions that people ask. If I lose my card, what do I do? You can reprint it online. It voids the prior card. You can also just ask for a replacement card. This is all on the website, and the link is here to do all that for yourself. Is there a difference between the laws regarding smoking and ingesting? No, not really. There are only limitations to how those manners of ingesting the medical marijuana are implemented. Like a medical marijuana item cannot look like a non-cannabis product that would be marketed to children. Basically, does it appeal to children? That's probably a no. And again, kind of just to tobacco laws as they currently are. If you know anything about that, you can't have your medical marijuana in the shape of an animal, vehicle, person, character. And edibles are mandated or regulated in 10 milligram, and that's the site down there. All that. Can I transfer my medical marijuana to a different state? No. In short, no. It's a state-specific issue. If you move from Arkansas to another state with medical marijuana, you would need to apply using that state's medical marijuana laws. Some states like Oklahoma and even Arkansas has a provision that allows for people that use medical marijuana in another state to apply for a visitor license or visiting patient card, I think is what the terminology is. And you can use medical marijuana if you apply through this process and go to that state for a temporary period of time. This is interesting because I've heard this in court before. I won't provide details, but can being a medical marijuana patient impact my parenting rights or custody rights? There's a specific protection in the amendment for people in this situation. If you need to reach out to an attorney to clarify this, please look at this amendment. Basically, it can't be used against them in this situation for custody purposes. This is another question that was presented to me. Can my doctor force me to smoke or ingest instead of the other? Not that I know of. I didn't see anything on the certification form, now that I think about it, that would limit a patient's use of medical marijuana. But they can make a recommendation to how you should. I think people would enjoy knowing that information. That's a conversation that you need to have with your physician who's certifying you. Reach out to them. Is there any risk of current accessibility of medical marijuana being stripped away? Kind of. This is interesting. These are all currently pending House bills. None of them have been passed yet, so keep that in mind. One bill would expand the definition of safety sensitive to include more jobs, thereby restricting or excluding more qualifying patients from the use of medical marijuana. HB 1566, it limits the type of physician that could issue a certification if that was withdrawn. Limits the process, like HB 1774, it would require a patient to consult with an actual pharmacist on site. And most importantly, Act 434 of 2021, which has already been enacted, it continues the 4% special privilege tax on medical marijuana. A special privilege tax means that it's taxed also, I mean, it means a lot of things, but in short, it means that it's taxed twice when the marijuana is sold from a cultivator to a dispensary and then from dispensary to consumer. There's two levels of taxation at that point, and it does increase it by that 4% mark. This is another question. This is the last question for this slide, just so you know, Paul, and we can transition to whatever. Considering how expensive medical marijuana is currently, how can we expand access to medical marijuana for low-income patients? Well, I can't just answer that easily. Cost is controlled by a wide variety of variables. It depends on the availability of the product. It depends on the limited number of cultivators that are currently providing or supplying that product, and the accessibility of the dispensaries to that product. Individual dispensaries, though, have taken steps to address this issue. They realize it's expensive. They're not turning a deaf ear to this. Some of them are being very proactive, and you can look at their websites to learn more about these programs. But one dispensary's programs for assistance included a compassionate need program, a compassionate condition, like some conditions that exceptionally benefit from the use of medical marijuana may be provided the discount, disability, age-based, and military discounts. Anyway, that's a summation of all the questions that were presented. And I'm free to talk about whatever. That's a lot of information. You can go into a lot more in detail, but that covers the general lay of the land as it is with medical marijuana. And if anyone finds themselves in any of these situations, or knows someone who is in one of these situations I've described, be it in the employment sector, criminal sector, gun-related sector, reach out to an attorney. I think it would benefit you tremendously to do that. With that said, I'm ready for.
All right. Well, thank you, Eric. That was very thorough. I did get a few questions. First of all, do you have to be a resident in your zone to go to a dispensary in that zone?
No. ability to purchase medical marijuana is not restricted by where you live, as long as it's still within the state.
Do you have to have a medical card to even go into a dispensary?
Yes. It's my understanding that you do, in order to get access, you do have to have a medical marijuana card. However, note that a medical marijuana patient, some of them are severely disabled and unable, they lack mobility or the opportunity to actually go to a dispensary to purchase marijuana. People in that situation can appoint or have someone be appointed as their caretaker. It's called the person has to submit a caretaker application. I'm previously early on in the talk about the exception for caretaker. That person can be licensed to go and pick up the marijuana for somebody in this position or purchase it for them. Or basically, it's somebody that can assist someone who can't do it themselves participate in the program. I know there's not that many caretaker cards that have been handed out. It's insignificant, I would say, almost compared to the number of cards that are in existence. I want to say maybe there's 1,000 caretaker cards. That could be wrong. Out of the 75,000 cards that exist here in Arkansas. So,
are there any local jurisdictions at a county or city level that are able to make laws that are more or less strict in contradiction with the state laws?
No, because a criminal, there's a little bit of nuance to that question. They can affect the city ordinances that may relate to the use of substances in certain areas, things of that sort, but the actual laws that give rise to possession charges, to delivery charges, which are the two most common, I would say, of drug charges, those are controlled strictly by state law. The state legislature writes those, codifies those, enacts those, however you want to word that. So a jurisdiction like Eureka Springs, Fayetteville, like I mentioned earlier, can make those types of arrests low priority for their city agencies or their county agencies, maybe in some scenarios. They can make those low priority where they don't arrest people or they just cite people or they give people warnings, but they can't change that law. That has to be done through the legislature.
Question from Logan. Are there plans to add more conditions to the law this year?
This year, I'm not aware of that, but I will say that a couple of years ago, I want to think maybe last year, one representative had maybe 40 plus more qualifying conditions. It didn't pass. It didn't pass or it was withdrawn by the sponsor. Either way, there have been efforts in the past, but currently can't think of any. So,
let's see. This is more of a comment, and this is kind of a sentiment that you hear a lot. Why is this an issue, but alcohol isn't, because it's a health issue? Are there any? Can you explain the distinction in the law between why alcohol is classified the way it is and marijuana is not?
Can I explain why marijuana, do you mean like, is it treated more harshly than alcohol?
Yeah, right.
Because they wrote it that way is the easy answer.
Sure.
But as to the actual policy that substantiates that, I'm not certain. And I think if they had a purpose for it early on as to why it was like that, I think that purpose has somewhat degraded or changed over time. Anything I say or anything I suggest is never going to be a representation of the policy of this library. But I will say that I do think that the causes that lead to those two things being treated differently merits reconsideration based on 48 states now having taken some proactive measure addressing THC as a substance.
When you were addressing the gun topic, you mentioned it's written in such a way that the medical use can be considered abuse. Someone in the comments questioned medical use is abuse.
Under federal law, it is. I think there's little argument to say that it's not. I'm not saying that it is on a practical level, but by federal law definition, the use of marijuana, be it medical, through a state mandated program or through a recreational program, if you're in a different state that provides for that, is still considered abuse of a narcotic. This is what I get at when I say that some of these things may require reconsideration in light of how states have acted. As long as the law stays the same as it is on the federal level, it is classified as some type of abuse. That is just the definition. I can't change that.
Are there any other common or not so common myths and misconceptions you encounter a lot?
No, I think I covered a lot of them. I get a lot of people that come at me that say that they have depression, anxiety. Can I get my card? Stuff like that. The answer is no, you can't get it based on that. But let's say that you have depression. It does cause severe nausea or something like that. You can get it for that reason. But as to any other specific issue, no. I think the gun topic is important, particularly for Arkansans, because Arkansas is, I think, the second most, has the second most number of people that possess guns in relation to their population. I think it's anywhere from like 58, 59, maybe 60% of the population owns a gun in some form or fashion. Contrast that with 3 to 5% of that population now has a medical marijuana card in some way. I think there's significant overlap there that needs clarification. So I would say I covered the things that I think merit looking at and what people learned about. If anyone has any questions as to certain policies or laws as they are, I'd be more than happy to look at them or entertain them.
Speaking of clarification, we just got a comment. He says, I got confused. Is a patient's Second Amendment rights strict or not?
Yes, they are under federal law. That I wouldn't say stripped, because the court didn't say stripped. The court said that the manner in which you exercise that right is controlled by laws. It's not a simple yes or no. Didn't just lay out a blanket statement that said no, you cannot have a firearm because of this. They provided a substantial reason as to why, and that's because that reason is built upon the way that the narcotic is classified. The court reasoned that there's a rational interest for the state to prohibit drug users, as defined by federal law, mind you, from using or accessing or purchasing guns. Again, agree or disagree, that's just how the court reasoned and reached a conclusion. It doesn't burden that right, it just controls the manner in which you may exercise it.
So is it accurate to say that a local law enforcement force is not obligated to act on that, but the federal jurisdiction can jump in and act on it? Is that what you're saying?
Yeah, you're thinking correctly. Like, you're going down the right path. An officer in Garland County, a Garland County Sheriff's Office, isn't going to look at the federal criminal code to enforce that law. That's somebody else's job. Their job is to enforce the ordinances of that county, that city, Hot Springs, whatever city it may be, or the Hot Springs Police Department. Their job is to enforce Arkansas laws. They're not going to try to pursue a federal charge against you. Again, that's somebody else's job. EA is a good.
We got a question from Michael. Is there more of a focus on physical ailments for medical use over mental? If so, why?
I would say, well, I've never thought about that question. That's actually an interesting question. Um, Thinking about the qualifying conditions as they are in Arkansas, it does seem to lean heavily toward physical symptoms. Um, I do know that there's a debate right now in the medical community about whether or not mental symptoms are, you know, like founded in physical ailments. But the way that the conditions are listed in the enumerated conditions do seem to favor a person's physical condition. PTSD is the big outlier, I would say. I can't think of the list. I'd have to refer back to my slide. But PTSD seems to be the one that is more in the mental realm. Um, why that is, I don't know. That's a question that should be presented to the Arkansas Department of Health and their like position on qualifying conditions, because they did reject bipolar affective disorder as being a qualifying condition. So there's not a good answer for that question, but it does provide interesting insight into it.
Are there any physical condition, or maybe not conditions is the right word, but state of beings that might overlap with your ailments, such as pregnancy, where you would be restricted from getting approved?
What do you mean? I don't understand.
Say someone has one of these ailments, and I can't think of another example other than pregnancy, but could the pregnancy, would that get them denied from being approved?
I don't know if it would get them denied from getting approved. I think that's a conversation somebody who is pregnant or looking to get pregnant should have with their physician. I can't think of any laws restricting what someone pregnant can do off the top of my head, but anything that could impact your pregnancy, I would definitely implore that person to talk to their doctor about what that can and can't do to them.
Are there any travel restrictions associated with medical marijuana card ownership?
Yes. You cannot take medical marijuana that's provided to you in Arkansas outside the state of Arkansas. Likewise for other states. If you cross state lines, you're getting into what's called federal jurisdiction. This is the lawyer in me talking at this point. If you do something that intersects with multiple states, you're invoking federal jurisdiction, because it's presumed that you're being involved in like interstate travel, commerce travel. You're affecting commerce in some way. Again, this is a lot to take in for that question, but in short, don't travel with your medical marijuana. If you're going to another state that has medical marijuana, just see if that state has a visiting patient program. Arkansas has a visiting patient program. If somebody in Oklahoma has a medical marijuana card and they want to come to Arkansas to visit with family for 2 weeks, they're welcome to apply for a visiting patient form and use the program here. But they cannot, and they really should not travel with it, just based on the liability that's involved with it.
There's what about any possession while in a moving vehicle? If you're not, kind of like you can't have an open container of alcohol in the car. What if your medical marijuana is in the car?
Yeah, your medical marijuana, this goes back to that slide from earlier. You really need to have your medical marijuana card on you. If you are choosing to transmit the marijuana, I've personally worked with people who've ran into this situation often, almost all the time, that a person has been had some type of interaction with an officer and faced possible arrest, and they had marijuana on them. That person immediately provided that officer with their medical marijuana card. And they didn't face any prosecution from that, which is really how the amendment or the constitutional amendments suggest it should be. The difficulty runs into if you don't have that card. That's when you can run into trouble. So if you choose to travel or go anywhere with your marijuana and you have a medical card, please have both of them together or available to you. Again, like I said, you can download your card to your phone and have that to you so they can look at the patient number and everything immediately.
Question from Logan: does the full faith and credit clause apply to the Arkansas medical marijuana laws?
Yes, I mean, it does, but the intricacy and the like, the nuance and the intricacy of how it does um, is a different talk. Um, that's something unto itself. That's really talking about how the supremacy clause interacts with the existing Arkansas law. I don't think I can answer that in any good way with the time permitted.
All right. Well, Eric, thank you very much. This was very thorough. Are there any final remarks you would like to make?
I would like to say that medical marijuana, even though it was enacted in 2016, it's still proving itself to be an interesting intersection of law here in Arkansas. It's produced a lot of litigation. It's added a lot of protections for people that qualify for the program. And I think as time goes on, we will get better answers for some of the questions and issues that are presented here. I would say that anyone who runs into any of these situations, they should reach out to an attorney. They're welcome to reach out to me. My contact information is provided at the beginning of this slide. It's my understanding that this will be posted somewhere later on. My contact information is there. You can reach out to Eric Wilson or any of the attorneys at the Shaw firm. We are located in Conway, but please keep in mind that we work all over the state. Most attorneys that you talk to will work all over the state. It's just a matter of, if you find yourself in any of these situations, that you find the attorney that works best for you and seems to know what they're talking about. With that said, I thank the Garland County Library and Paul for providing me an opportunity to talk about this. I think it's interesting. I think it will continue to be interesting as these laws change in the state and all over the nation in the years to come.
Absolutely, you're welcome, and thank you for doing it. Like you just said, that there is a recording of this broadcast. It'll be available immediately in our videos tab on the library's Facebook page, and it should be available tomorrow on YouTube. It usually takes several hours, so overnight, for the YouTube link to be available, but feel free to share that with anyone you think this information would be useful to. And like I said at the beginning, if you have any law-related topics that you would like to see an attorney present about, like this one, please let us know. So we might have Mr. Wilson here back, or someone else. We're trying to get a wide variety of voices on a wide variety of topics. So again, appreciate you, Eric, and appreciate everyone for watching. Have a good evening.
See ya. Bye.